The trial chamber finds that the damage caused to houses in Bjelovac and Sikiric likely resulted from all these circumstances. For the reasons given in the judgment, the trial chamber is not in a position to know how many houses were destroyed by Bosnian Muslims and how many were destroyed by other causes. Consequently, there is doubt whether the amount of houses destroyed by the Bosnian Muslims fulfills the large-scale requirement for the crime of wanton destruction. As a result, the trial chamber is not satisfied that the destruction of property in Bjelovac and Sikiric between 14th and 19th December 1992 by Bosnian Muslims fulfills the elements of wanton destruction of cities, towns or villages not justified by military necessity. On the 7th and 8th January 1993, Kravica, Silkovici and Jezestica were attacked by Bosnian Muslim fighters from Suceska, Klogova, Bilijek, Mosici, Delici, Cerska, Skugrici, Jaglici, Shuchniari, Brezovaniva, Ozmace, Konjevic Polje, Jagodnia and Josheva. Also, the accused and members of his group of fighters participated in the attack. The fighters were followed by thousands of Bosnian Muslim civilians. At the time of the attack, there were relatively well-armed village guards and some Bosnian Serb civilians in Kravica, Silkovici and Jezestica. Evidence shows that there was also Bosnian Serb military presence in the area. The attack met with resistance. Bosnian Serbs fired artillery on the attacking Bosnian Muslims from houses and other buildings. Houses in the area were burning. In Jezestica, Bosnian Muslim fighters and civilians set many houses on fire, causing destruction on a large scale. In Kravica, property was also destroyed on a large scale. However, the evidence is unclear as to the number of houses that were wantonly destroyed by Bosnian Muslims as opposed to other causes. As to Silkovici, there is insufficient evidence to establish that property was destroyed on a large scale. Considering that Bosnian Muslim villages in the vicinity of Jezestica had previously been attacked by Bosnian Serbs also from Jezestica, the trial chamber does not exclude that a military justification for the attack on Jezestica is conceivable. However, such justification cannot extend to the resulting wanton destruction of property, especially since this was neither of a militarist nature, nor was it used in a manner such as to make an effective contribution to the military actions of the Bosnian Serbs. Consequently, the trial chamber is satisfied that the destruction of property in Jezestica on 7th and 8th January 1993 by Bosnian Muslims fulfills the elements of wanton destruction of cities, towns or villages not justified by military necessity. We will deal now with the responsibility of the accused. Shall now deal with the question whether the accused Nasser Orić is criminally responsible for these crimes of wanton destruction in terms of Article 7.1 and then Article 7.3 of the statute. We shall start with the alleged individual criminal responsibility of the accused pursuant to Article 7.1 of the statute, specifically with the aspects of instigating and or aiding and abetting, and also the omission which the prosecution attributes to him. The trial chamber holds that instigating requires influencing the direct perpetrator by way of inciting, soliciting, or otherwise inducing him or her through acts or culpable omissions to commit the crime in question. The instigation must substantially contribute to the perpetration of the crime, and the instigator must intend not only his or her conduct, but also the ultimate crime. Aiding and abetting may be constituted by an accused's contribution through acts or culpable omissions to the planning, preparation, or execution of a completed crime, provided that the contribution is substantial enough to make the commission of the crime possible, or at least easier. The aider and abetter must act with an intent to further the contribution, as well as to effect the completion of the crime by the direct perpetrator. In both modes of liability, the contribution can be indirect, as well as removed in time and place from the actual commission of the crime. The trial chamber examined the alleged criminal responsibility of the accused pursuant to Article 7.1 of the statute only in respect of the attack on Jezestica on 7th and 8th January 1993, as the elements of crime of wanton destruction are not fulfilled with regard to the other attacks for which such responsibility has been charged. The trial chamber has no doubt that the accused was generally aware that Bosnian Serb property was destroyed by Bosnian Muslims, primarily civilians, who followed fighters during the attacks. However, the prosecution has failed to adduce reliable evidence that he instigated wanton destruction. On the contrary, evidence indicates that the accused opposed this kind of conduct. With respect to aiding and abetting, the trial chamber finds that the accused, by virtue of his authority as leader of a group of fighters, had the responsibility to prevent the commission of wanton destruction by his subordinates. This duty extended to preventing wanton destruction by other fighters and civilians if the accused knew that such wanton destruction was being or was about to be committed in the course of attacks in which his subordinates participated. As a minimum, he had a duty to prevent civilians from being present during such attacks. However, it has not been established that the accused could have prevented wanton destruction by civilians who were present before, during, and after attacks in massive numbers, and such such as being beyond any control. With respect to fighters, the trial chamber is not convinced that in the particular circumstances of the attack on Jezestica on 7 and 8 January 1993, the accused could have prevented fighters from committing destruction or aiding and abetting civilians to commit such destruction. There is no evidence that his own fighting group had any involvement in the wanton destruction that occurred during the attack. Furthermore, there is no sufficient evidence that the accused had control over or even communication with the other fighting groups during the attack. In addition, although the accused participated in the attack, there is no evidence that his presence was that or amounted to one of approving spectator, which is a qualification required to hold the accused responsible for active participation under Article 7.1 of the statute. In the light of the above, the trial chamber concludes that the prosecution failed to establish that the accused in any way instigated or aided or abetted pursuant to Article 7.1 of the statute the commission of wanton destruction not justified by military necessity in Jezestica on the 7th and 8th January 1993. The trial chamber also examined in the judgment the superior responsibility of the accused pursuant to Article 7.3 of the statute only in respect of the attacks on Ratkovici and Gornji Ratkovici, which occurred on the 21st of June 1992, on Brajevina, which occurred on the 27th of June 1992, and Jezestica, which occurred on the 8th of August 1992 and 7th and 8th of January 1993. As the elements, this is so because the elements of wanton destruction are not fulfilled with regard to the other attacks for which such responsibility has been charged and with which I dealt with earlier on. Regarding all four attacks, the trial chamber heard evidence that Bosnian Muslim fighters and civilians perpetrated acts of wanton destruction, but there is almost no evidence that would further identify these perpetrators. However, such identification in any case is not required by law, provided it can be established that those responsible were under the control of the superior. With respect to the question of the existence or otherwise of effective control by the accused over the perpetrators, it has already been explained that effective control can be based on a de jure as well as on a de facto position of authority. We have also already explained how on 20th May 1992 the accused was elected as commander of the Srebrenica TO staff, and at the time of the attacks of Ratkovici and Gornji Ratkovici and Brajevina in June 1992 still held this position, in which he was confirmed on the 27th of June and again on the 8th of August 1992. In addition, by January 1993, when Jasistica was attacked the second time, the accused had in the meantime been appointed as commander of the sub-region, which was proclaimed on the 4th of November 1992. Thus, on a de jure basis, the accused was considered as superior to all Bosnian Muslim armed groups operating in the Srebrenica area during the time period relevant to count 3 of the indictment. However, while the trial chamber finds that the accused exercised effective control over his own fighting group from Potocari, there is insufficient evidence to establish that he de facto exercised effective control over the various groups of fighters participating in these attacks, not to speak of the civilians who follow the fighters. The picture that emerges from the evidence is not one of an organized army with a fully functioning command structure, but one of local groups of fighters remaining relatively independent and voluntary, and a mass of uncontrollable civilians that were present at every attack. Therefore, the trial chamber has come to the conclusion that regarding all 4 attacks under consideration, the accused cannot be held criminally responsible under Article 7.3 of the statute for wanton destruction of cities, towns or villages not justified by military necessity. And we come to sentencing.